There's been roughly three cases. Landlord-tenant law just doesn't have a lot of cases that go to the Supreme Court. And cases that go to the Superior Court level, just to remind everybody, eviction cases are held at the district court. Normal cases are like a quiet title action is held at the Superior Court level. So like district court is misdemeanors, if you think of it like that. Superior Court is felonies. There's no appellate court for civil cases, only for criminal cases. And then there's the Supreme Court. The Supreme Court for civil cases is the only court that when they make a decision, it applies to every other court in Alaska. If the Superior Court makes a decision, it's just one judge's opinion. It's binding, but it's just that one judge. Okay, so there's only been like three cases in the past like 3 to 5 years that really talk about landlord tenant. As you guys would imagine, when you're talking about rent and the price that you get for rent, it rarely makes sense to pay the amount of litigation costs that I was talking about to go all the way up to the Supreme Court. Like it just financially, those numbers don't balance out. So it doesn't happen very often. So when a case has come through, they're very noteworthy. A couple of cases have come through that answer a question that I want to convey to you guys because I like what has come down. In general, landlord-tenant law hasn't changed a lot from when the rules were first put in place. The court's not deviating from the statutes very much. It's applying the law in the way that you would expect it. One of the things that's been clarified is your ability to be reimbursed for reasonable attorney fees. So this is important because I don't know if you've ever had an attorney before tell you this, but you can't stop yourself from being sued by someone, especially a crazy person. There's no real way to prevent somebody from naming you as a defendant in a lawsuit, even if the cause is completely invalid. You can't prevent that process from happening. And so, for a lot of the people who've made it to the Supreme Court, it's because a defendant refused to drop the case. They might not even have an attorney. They might have just had enough of an argument to get to a judge, and then they have a right to appeal that to the Supreme Court, which makes the landlord have to spend money in order to stay in the case, and they're required to do that. Additionally, this is going to tie into a thing that we didn't talk about today. If you have your property in an LLC, you are required to have an attorney, which is another way that this can punish you. And the reason why this is interesting is if you're required to have an attorney, it certainly makes a lot of sense to know whether or not you can have those fees be reimbursed at the end of the day. Admittedly, most of these tenants are evicted because they can't pay rent. And so having a judgment at the end of the day for a big pile of attorney fees is usually just a fancy piece of paper. But every now and then, it's a good thing to have, especially if you have a tenant who one day might buy their own property and you have a judgment against their name. And when they sell that property 10 years down the line, suddenly you get a random check for $20,000 that you never really thought you were going to get. It can still be helpful. So these courts have talked about that even though the cases, I should probably talk about this from the other direction. These cases are helpful to know from a risk perspective because this analysis applies to a defendant just as much as it applies to a landlord. If your defendant gets represented by an attorney of any sort, and that attorney racks up fees and they win a case against you because you failed to return their security deposit on time, and technically they've got you, and you missed it by 2 days and they decided to litigate the whole damn thing over $400, right? And they win that case. And then the attorney for the defendant seeks reimbursement for $25,000 of attorney fees. The Supreme Court says they're allowed to do that. It works in reverse, so it's beneficial to a landlord, but it's probably most impactful for people to know for risk management perspective. And so when I tell people don't go to court, just pay people to get out from underneath things, hopefully some of what I'm saying now makes a little bit more sense, where if you go and an attorney representing the other side and they happen to win on a technicality, which is, as every attorney will tell you, the best way to win, you could be on the hook for a really, really big bill, even though the amount of damages is extremely small. The statutes and the way that the Supreme Court has read them is that you will be on the hook. That's my update for the law. That comes from Guilford v. Widener as well, the second one. And there's a few other cases that talk about that as well, including a situation where a probate of someone who passed away, they had a piece of real property with a tenant inside of it, and then there was a question in probate court about what the probate was allowed to do. And so that's complicated, but at the end of the day, they were talking about how much the attorney could be reimbursed for their fees.